Hello everyone, welcome to my channel. Before watching this video, don't forget to like, comment, and subscribe. Now let's start this video. Implementation of the principle of maritime law in a special terminal as the main supporter of the oil and gas business. Based on Law Number 17 of 2008 concerning sailing of the Republic of Indonesia, State Gazette of 1992, Number 98, Article 1, Numbers 20, 21, 22, 23, and 24 states terminal is a port facility consisting of berths and berths or berths, place or stockpiling, place of waiting and up-down passenger, and or loading and unloading places. The special terminal is located outside the work environment area and the port interest area, which is part of the nearest port. Self-interest terminals are located within the work of environment area and regional environmental interests, which are part of the port to serve their own interests in accordance with their main business. The work environment area is a water and land area at the port or special terminal that is used directly for port activities. Regional environmental interest is the waters around the working area of the port waters that are used to ensure the safety of shipping. The scope of Pertamina oil and gas special terminal in Indonesia is still referring to the control of the assets of local business units both on land and at sea, so that the implementation of maritime law, which is the basic reference for managing the special terminal, is negligent and cannot properly apply the principle of balance, harmony, and harmony. Based on the above definition, a special terminal of a company or business entity is built to support its business activities so as to better guarantee the safety and security of shipping and protection of the marine environment, with the location of the area outside the work environment area and the environmental interest area of a port, while the operation is legally following the main provisions in force at the nearest terminal or port in accordance with the work environment area and environmental interest area that have been determined by the Minister of Transportation. According to Article 103 of the Shipping Law Number 17 of 2008, as a special terminal, it must place government agencies that have shipping safety and security functions, as well as agencies that carry out government functions in accordance with needs, such as custom agencies for receiving imports of goods or cargo on ships which enter the international special terminal. In terms of fulfilling obligation towards the law to be more effective and economically, technically, and operationally more efficient and more secure in the safety and security of shipping, business entities, both national and regional, must consistently carry out activities in accordance with applicable codes, namely ISPS code and ISM code for ship entering the terminal area, and or other safety provision as a form of carrying out the duties and responsibilities, as well as the authority to manage the special terminal according to the permit based on the decision of the Minister of Transportation of the Republic of Indonesia under the supervision of the local Syahbandar. The special oil and gas terminal is the place where the shipping contract between carrier and shipper owner will be accepted by both domestic and international consignors, whose requirements include vessel readiness or seaworthiness and port readiness, port and its operational supporting port or safe ports, berths, and facilities. Balongan Oil and Gas Special Terminal implements a commitment to implement maritime law principles in the port that guarantees the safety of ships in the terminal with optimal service, while ensuring the interest of the terminal in the transfer and receipt of cargo, preventing demurrage, cargo losses, and being aware of accidents at sea that will all incur commercial losses for ships and terminals. In full can be conveyed that the law of the sea and maritime law has a close and full relationship with activities at sea, which also originate at the 1982 United Nations Conference on the Law of the Sea, or UNCLOS 1982, which had held talks 3 times as much as 1958, 1960, and 1974. According to Malcolm McLuhan, lecturer in Business and Law, Glasgow College of Nautical Studies, UNCLOS, first attempts to codify the international law of the sea. Second, is a treaty document of 320 articles and 9 annexes governing all aspects of ocean space, such as delimitation, environmental control, marine scientific research, economic and commercial activities, transfer of technology, and the settlement of disputes relating to ocean matters. Trade came into force internationally on 16 November 1994. The law of the sea is more like a public law. Regulates the principle and basic provision that get the translation in maritime law. Maritime law tends to be more directed. Maritime law tends to be more directed towards commercial law because there are so many provisions regarding the implementation of safety and security requirements and maritime environment protection as prerequisites for contracts and transactions regarding the transport of cargo by sea and port. This is in accordance with the opinion of Charles de Batista, which states that the maritime law is commercial law, and in line with Purvasachipta opinion that the law of the sea, which is civilian for companies, is commercial law or trading law, which also means commercial law. The importance of the utilization and management of marine potential as a means of trade for the strength and prosperity of the country was stated by philosopher Alfred Temanan, 1660 until 1783. The profound influence of sea commerce upon wealth and strength of countries is its growth and prosperity were detected. Another Alfred Temanan statement, the key to being dominant over the country lies in its ability to control the ocean. Indonesia, as the one of the International Maritime Organization member countries that have ratified the ISPS Code, has the same obligation to implement its provisions. The government of the Republic of Indonesia intensively prepares some initial basic activities since mid-2003. Hold socialization with the maritime community, selects port facilities in an effort to implement the provisions of the ISPS Code, prepares a century organization or a recognized security organization, declares ISPS Code implementation. In the national port under contains the rules, function, and hierarchy of the port. In Law Number 17 of 2008 concerning shipping in the port has ruled as first, nodes in the transportation network according to their hierarchy. Second, the gate of economic activity. Third, the place of transfer of mode of transportation activities. Fourth, supporting industrial and or trade activities. Fifth, place of distribution, production, and consolidation of cargo or goods. And sixth, realizing the insight of the archipelago and state sovereignty. Of the 1,034 countries according to the Global Competitiveness Report 2009 until 2010, the competitiveness of ports in Indonesia is ranked 95, a slight increase from the 2008 position, which ranked 104. However, Indonesia's position was inferior to Singapore, Malaysia, and Thailand. The weakness of ports in Indonesia lies in the quality of infrastructure and superstructure. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.